A federal high court in Abuja has barred the Central Bank of Nigeria, CBN, from disbursing monthly allocations to the Rivers State government, citing constitutional violations by Governor Siminalayi Fubara. The court found that Fubara's presentation of the 2024 budget to a four-member House of Assembly breached constitutional protocol, rendering the budget illegitimate since January.
Now, Justice Joyce Abdulmalik declared that decisions made by the four-member Fubara-backed assembly were void, referencing prior rulings by the Federal High Court and the Court of Appeal. The judge emphasized the CBN's responsibility to ensure state budgets are approved by a constitutionally recognized House of Assembly before releasing funds. Now, joining us is the former chairman, Degema Local Government Area, Rivers State, a legal practitioner and a public affairs analyst, Sogbe Eli. Good morning and thanks for joining us.
It's my pleasure to be here. Thank you very much.
Good to have you.
We're also joined this morning by the Publicity Secretary, Rivers State Caretaker Committee, Chibike Ikenga. Good morning. Thank you very much for joining us.
Good morning. Thank you for having me.
All right, I think we'll start off the conversation, gentlemen, by looking at the court's decision. And, you know, this decision follows a suit filed by the Rivers House of Assembly faction led by Martin Amewule, challenging the legitimacy of the four-member faction loyal to Fubara. And I'll begin with you, Mr. Ikenga. Your thoughts regarding, you know, this court's decision to bar CBN from paying federal allocation to Rivers State going forward?
Okay, thank you. I think that the decision yesterday is a consequential judgment, you know, to drive home the point that when court decisions are made, when court judgments are made, that we as citizens or organizations and institutions of government are bound to obeying them. Chronologically, you'd recall that Justice Omotosho had, in the judgment he gave, directed that the only recognized, legally recognized House of Assembly is the one led by Martin Amewule, and that the budget or the appropriation bill must be presented to that house, and that any other house, quote and unquote, like the one created by Rivers State government, a three-man committee, are not known to law. The government of Rivers State refused to obey that judgment. That matter, again, about the judgment, the Court of Appeal voided that so-called budget that was presented to the three-man committee under Okojumbo, and went further to directing the governor and the Rivers State government to represent the budget to the Martin Amewule-led Rivers State House of Assembly as the legally recognized House of Assembly. The government of Rivers State also ignored and blatantly refused to obey that judgment by representing the budget. So as a consequence, when you take laws into your hands, you face some consequences. The Rivers State House Assembly, under right of Martin Amewule, went further to asking the court to do the needful by punishing those who refuse to obey court orders, who refuse to obey constitutional provisions, because it is the constitution that brought in the existence of Rivers State House of Assembly. It is also the constitution that brought in the existence of the executive, which the governor, Governor Siminalayi Fubara, is the governor. So you must abide by the prescriptions of the constitution, and the Rivers State government, having failed to do so, the court will not sit idly by and watch its decisions, its judgments being ignored. And if the court does not take proper decision to ensuring that its judgments are that they compel obedience from those who are affected, the judgments will just become an ordinary piece of paper, worthless piece of paper. So it was on the basis of that, Justice Abdulmalik went ahead to direct them that since they refuse to obey, there is no existing appropriation, and the government cannot continue to draw funds from the Rivers State Consolidated Revenue Fund, and that they remain stalled pending when a proper appropriation had been submitted to the Martin Amewule-led Rivers State House Assembly and passed. That is the cross of the matter.
All right, let's quickly bring in Mr. Sogbe Eli, you know, to share his view on this as well. You know, I got to see lawmaker Ikenga Ugochinyere state that, you know, he found it improper that a court would give such a ruling when the matter is currently being appealed, you know, in court. So let's quickly, I mean, you're a legal practitioner, so let us know what you think. Is there anything, you know, wrong with the ruling that was given yesterday, keeping in mind that, you know, that matter is being appealed and is still being adjudicated in court?
Okay, let's just begin by saying that we're headed for a constitutional crisis, an avoidable one at that in this country, because we've allowed politics to override the law. The law is now made a subject of political abracadabra. See, in law, we say, from the point of view of the decision of Lord Denning, of blessed memory, in the case of UAC against McFoy, you don't put something on nothing and expect to stand. If a thing is bad, ab initio, it's incredibly bad, they can't do anything, you throw it away. The reason why you're having problems confronting the judicial, it's unfortunate that the judicial has allowed this. Some judges are allowing this to come to pass. We operate a legal system where, in the hierarchy of courts, lower courts are bound by decisions of superior courts. On the issue that is bedeviled university at the moment, for crying out loud, it's a settled law that in the central we find ourselves, where defectors have moved from the party that sponsored the election to another party, the remnant of the House of Assembly can sit. Go and look at Section 102 of the Constitution. Go and look at the case of Dapelong versus Darie, Michael Dapelong and others, attempt to impeach the governor, just for Shibidari of Plateau State. The House of Assembly in Plateau State at that time was depleted. About 10 members moved out of 24 of them. And the court said, look, those who are left behind are the House of Assembly of the state. However, what they cannot do is exercise the power of impeachment. It is settled law. Now, every judge of the Federal Court or Appeal Court knows that that's a law. That decision was made in, I think, 2007, yes. Then by immediate past CBN, or the one before immediate past Justice Walter Samuel Kano Nogan. Go and read. This is our judicial precedent, and we call it the doctrine of stare decisis, let decision stand. Today we'll have judges of lower courts reviewing judgments of superior courts. And don't forget that this is tell on us. When the courts refuse to do what the courts should do, you're compelling disobedience by the public, because, see, that's what they call the court of public opinion. They have the facts. They know the facts. In our laws, a coup is unconstitutional. But if a coup succeeds in overthrowing the government, he acquires the token of legitimacy. That doesn't mean it's constitutional. It's an aberration of the Constitution. Here, where people have defected from their party, the facts are in the public domain and we're running away from the facts. Now, these people come back and you go behind the courts to legitimize their illegality. If you have gone to court to seek a judicial review, you must come with clean hands. These people defected, that's the crux of the matter. They were elected on the same platform with Fubara as governor. They elected on their own to leave the party. Now they've gone further, they've found out, look, on the wrong direction. They made the U-turn to deny the defection, and the courts that have taken judicial notice of these facts are going ahead to give judgments that are in conflict with superior decisions of the Supreme Court. I don't understand. As a lawyer, I'm minded to understand that the law is supreme. Look at the Constitution of our country from Section 1. It says the provision of this Constitution shall bind on all authorities and persons. On all authorities and persons, including the president, including judges of courts. So if the Constitution says this is it, why would anybody in his imagination imagine that Section 102 doesn't exist? And moreover, the court have brought life into it. In the case of Dapelong against Darie, those people can sit. They did not defect. And the House of Assembly cannot come to the hall because some people decide to leave their seats. In any event, on the other side of the university, a speaker had already given effect to that defection, Section 109 sub 2, according to the Constitution. They did not appeal that. Now, as we speak here, that letter that speaker wrote to INEC has not been attended to since January last year. And of course, in a matter, one of those, a lot of matters, as I speak to you, 32 cases on the count, on the balance already, in the Federal Court Abuja. And a lot of things are being modeled where we're allowing politics to override the law. It's not done anywhere in the world. Democracy, first and foremost, is built on rule of law. Here in the studio, too, as journalists, you're making the same mistakes. Section 22 of the Constitution gives you the power as the father of the realm. My friend on this panel, Ikenga Chibike, was appointed by the National Working Committee of the APC as a member of the Executive Committee. That appointment has been nullified duly by a court of law, court of competent jurisdiction in Rivers State. Even if he has gone on appeal, he cannot call himself here APC Public Secretary. It's not. It is valid in Uju. But here we are. It's not about aberration, it's not about disobedience of court orders and consequential orders. This is one concept that should send him to jail for contempt. But here we are. He does it with impunity and goes out because now, in Rivers State, let me remind you, let me call to remembrance. In 2018, what the Senate have had a Congress or Congresses against the judgment of the High Court of Rivers State, started over by my Lord, the Honorable Justice Chion Wogu, who proceeded and had an executive committee at state level led by Juga Iflaga Makri, current director of Energy Security in the Office of National Security Advisor.
All right.
By 2019, the court nullified all of that. We didn't have candidates. The courts, even though had the NWC backing the party at that time, the judicial on one side. Now, it does not know that that can happen. So the media should not aid and abet these things that happen in Rivers State. The superiority of the law over the politics is final. It's in Constitution. So first thing first, if you want to deal with the Rivers State crisis, deal with the Constitution the way it is. The Constitution says there are courts of higher jurisdiction. It is spoken, there's just a binder final on everybody. So until we deal with the issue of the defection of Mail and Co., they have no legitimacy to demand for anything. They cannot come to equity with dirty hands.
All right, hold on, Mr. Eli.
Mr. Ikenga, I think we'll bring in Mr. Ikenga, in on the conversation. There are a number of things that Mr. Sogbe has said, and would like you to respond as well. He's also challenged your position as in the caretaker committee, stating that it's been nullified. I would like you to react to all of that.
Okay, quickly, thank you. So where Eli had expressed his emotions and sentiments about defection of members of the Rivers State House Assembly. Defection is not substantiated, predicated on emotions, sentiments, and even bitterness. But what we know is that the court, two courts of competent jurisdiction under Justice Omotosho, confirmed that the members of Rivers State House Assembly known to law are the members under Right Honorable Martins Amehuli. The Court of Appeal also confirmed that the members of the House of Assembly Rivers State that are known to law are the ones under Martins Amehuli. And then the Court of Appeal also voided the 800 billion budget purported to have been presented to the three-man committee under Okojumbo. That is what the position of the law is. That's what the Constitution is. And then let me also come, when there are interactions amongst persons, or organizations, or institutions, there are bound to be conflicts. And when those conflicts arise, it is the responsibility of the judiciary to intervene and ensure that we get back to equilibrium. That's what the judiciary is doing. So for my friend Sobwe to stay there and say, oh, this is what it is, that's his own personal opinion. That's his own personal sentiment. I'm talking about what the law and the courts have said. And the Constitution is the issue here. You must respect the prescriptions of the Constitution, which is what the Rivers State government has not done. And then let me go further. He mentioned his name. He said he's a former council chairman. This man was elected as local government chairman of Degema, and court voided it. And up to today, it has not been set aside. But he introduced himself as a member of, as a former council chairman. That's one. And then two, let me also say, there is a subsisting Supreme Court judgment which says that courts are barred from interfering with the internal affairs of political parties. It was on the basis of that Supreme Court judgment that the national leadership of the party under Alhaji Omar Ganduje, through his National Working Committee, which got powers, or the National Executive Committee, which ceded these powers to the National Working Committee under Ganduje, appointed us to superintend over the party because the dissolved executive, the former executive of the party, failed to ensure that the party's fortunes were brought to the fore. They failed repeatedly over time. They were involved in anti-party activities wherein they supported Vice President Atiku Abubakar against President Bola Ahmed Tinubu. This information is with the national leadership of the party. And then they christened us as caretaker to mobilize the party, reorganize the party, and usher in new executive through a congress, which has been fixed now on the 16th of November for what congresses, 23rd of November for local government congresses, and then 30th of November for the state congress to usher in the properly elected executives. That given, but the point here is this. The governor of Rivers State took oath of office and oath of allegiance to protecting the Constitution. But unfortunately, Rivers State government had been seen, particularly the executive, in the media, attacking judges, attacking judgments. That's very unfortunate. That's executive rascality. It is not necessary. It doesn't help us.
Yeah.
Allow the Rivers State House of Assembly to do their work while the executive does this stuff.
Just for clarity.
So there be checks and balances.
Yeah,
but trying to push them aside to continue to drive the interests of the person or the group of persons who share their interest in the executive is most unfortunate. The Constitution must be obeyed, respected, and for us to have peace, tranquility, and development, we must ensure that we abide by the prescriptions of the Constitution.
Yeah, just for clarity, we're going to have, Mr. Eli, respond. But just for clarity, what argument do you have in particular? Is it that the defections do not necessitate them being removed as lawmakers, or that they didn't defect? What is the main argument here?
Okay, thank you. The courts have affirmed that they did not defect because defections are not just mounted. You must resign from your party, you must show proof, you must register in the new party you have defected to, you must show proof by showing your membership card and showing that you have been paying subscriptions as required. But in this case, the fact that you have signaled an intention, you love the policies and programs of a political party, and that you intend to join them, even if you have mounted so, you have not done so, you have not consummated the processes required in the registration and membership of a new party. The courts have also aligned with us that these are facts, that they are not members of any other party other than the PDP that got them elected.
All right, we'll have Mr. Sogwe Eli respond to all that you've said, but also, just to ask regarding this current situation, the judiciary has been accused. Mr. Ekinga has said that all of this amounts to executive rascality. But we've also seen the judiciary being accused of judicial rascality in how this has been handled. So what is your response or your thoughts in response to the statement that Mr. Ekinga had said that the court had said that they have not yet defected? They didn't defect because there were no indications through their actions. And also, do you consider how these matters have been handled as judicial rascality?
Unfortunately, Kinga is not a lawyer, so he's speaking a lot of abundance of ignorance. I said here, and I want to repeat, that our courts created by the Constitution they function by hierarchy. Once a matter of law, a piece of law is settled by judicial interpretation, it binds on courts below. Normally, even without prompting, a judge sitting in the federal court will not even tamper with discussing defection. After the Supreme Court has spoken in Ifeda Abegud against Undeserved Assembly, after the Supreme Court has spoken in a lot of cases, including the one I cited before, the Michael Dape-Along versus Joshua Shibidari and others. Now, it says, it keeps calling Justice Omotosho's court, and I want to laugh. I want to laugh. Justice Omotosho had the matter for him when the president intervened because he thought it was an internal PDP affair. The governor, on his part, withdrew his counter-affidavit, withdrew his defense. So what was before Omotosho was no longer a fact of defection, as grounds for the governor refusing to honor these supposed lawmakers. That he has ignored. What Omotosho gave was a consent judgment because there was no position. And in law, when there's a consent judgment, if you file an appeal, for you to succeed, you must show special grounds why you must be heard, because you are deemed to have abandoned your defense at the trial court. There's no witness box in the Court of Appeal or in the Supreme Court where you go and tender fresh evidence. In the certain circumstances, you can do so. Otherwise, you can't do so. So the issue of defection has not been determined. He's making reference to what they had a judge of the High Court of University say under Section 272 sub 3. right, after the law was amended last time to take away that power from House of Assembly, from state high court to federal high court, which was not a debate for that day anyway. But what we're discussing here in section 272 is not about vacancy in the House that arose from death or resignation of membership or appointment of a member of Assembly to maybe another office. We're talking about the section that's section 109 sub 1G, which has been settled. And in law, once the matter is settled, a judge of a court below takes judicial notice. It's not to foreign into it. Nobody needs to remind him. Now, the reason why we have this crisis in Rivers is because we allow politicians who do not respect the law, who hide under the law, to commit a crime. Now, we have a situation where an armed robber came to your house, violated your privacy, raped your children, took your property, and now ran to court to get an injunction to rescue himself, to shield himself from the consequence of the law. And you know the facts. The public knows the facts. So the court itself puts itself on trial. So what's happening in the that the judiciary is the one that's putting itself on trial because the court itself is not obeying the doctrine of silent decisions, which is judicial precedent. Now, no court has said so. No federal court in this country has tested evidence of defection. And there's no way they said you must come with evidence of payment of fees in another party. You must not arrest that. On the floor of House Assembly, this member is defected. The world knows it. Everyone knows the facts are there. So what should be talking about? Those people should actually be let them face trial for perjury. It is denying that fact. So what we are dealing here with is where politicians have sat down somewhere, plotted to remove a governor that they brought to office. That plot failed, and the State must not have peace because somebody's ego is bruised. It cannot happen, and shouldn't happen. Yeah. So the issue with interrogator, for you to say you want to solve a budget, again, going back to the issue of judicial precedent, my dear panelists, the Supreme Court has spoken in the case of Attorney General of Lagos State, the Attorney General of Federation, in 2004 on this subject, where President Olusegun Obasanjo ordered the seizure of council funds in Lagos State. Because Lagos State Governor, there now President Bola Ahmed Tinubu, lead the House of Assembly, created local government councils in Lagos State. Now the law is that if you create a local government council, you must have a concurrence by National Assembly. So the Supreme Court said, whilst that creation was inchoate, and that was incomplete, the President, then Governor, was right to create a local government council. Therefore, the President at that time, and Commander-in-Chief, Olusegun Obasanjo, cannot withdraw Lagos State funds. There is statutory organization, statutory body, other constitution. You cannot do that. You cannot do that. That paper was delivered in 2004. Fast forward to 2024, 20 years after. The governor decided the crisis in Lagos is now president. Under his nose, under his watch, people are taking the same routes. And the court is in Abuja, ignoring what the Supreme Court has said in 2004, 20 years ago, and gives an order to withhold allocation.
Does it make any difference? Does it make any difference in these two cases that the earlier one was, the presidency directing that happens, but in this case, we can't clearly say that it was the president that made this happen? I'm not saying president directing. I'm saying under his watch. All right. Judicial presidents are ending and final. The Speaker has spoken, so a court of competent jurisdiction at the level of federal court or appeal court will stay away. You can't do that. You're bound by it. Yeah. A pronouncement of a law court is like a law itself. In this case, Supreme Court has said you cannot withhold the funds that go to an arm of government or a tier of government because there is some kind of dispute. You cannot do that. So what my Lord, the Honorable Justice Joyce Abdulmalik did yesterday, with respect to her, is foraging to sit on appeal on the last decision of the Supreme Court. Since 2014 now, no government, there have been how many presidents? No government has attempted to do that. All but right. Here we have reviewing the judgment of the Supreme Court. I was saying that's okay, that's not okay. As a lawyer, I will not sit there and tell you that's the law.
All right, Mr. Eli, hold on.
He has no locus to sit here as an APC, whatever. He does not have. And I'm not ready for all those things. I speak and I say emotion. I cited law, I cited judgments.
All right, kindly hold on. Currently, hold on. Let Mr. Kinga also have his views aired. I would like that Mr. Kinga also respond to the point on the 2004 judgment by the Supreme Court on then Governor Bola Tinubu when he was governor of Lagos State. Is that in any way relevant to what we are currently seeing today? And do you, in any way disagree with the point that if there's been a ruling in the past, then we cannot be seeing Justice Abdulmalik, give a ruling completely different today concerning River State? And You know, I mean, is the court, are they also getting involved in politics from what we're seeing here?
Okay, thank you. Firstly, I'd like to say that Soboye, who is there, we know him in Rivers State. He has been an APC member. He is also involved, like he has been in APC, in repetitive academic postulations. He did not and has never won any case in any court as a lawyer, as he brags. We are aware of that. Let him prove me wrong. He has never won any case. So be that as it may, let me say here that what we are talking about here is about decisions of courts that were blatantly or flagrantly disobeyed by Rivers State government. And if you do so, there are consequences. I want to say that the case of Lagos State about creation of LCDAs was not contemplated by the Constitution, and there is no provision in the Constitution. Let him quote these relevant sections that says that so and so thing will happen, particularly seizure of funds if a state creates a local government. But in the case of refusal to pass appropriation bill to law, there are specific provisions in the Constitution which says you cannot draw funds from consolidated revenue fund of a state if appropriation bill was not submitted and passed by the legally constituted assembly. That is a fact. So, as well, impugning the character and integrity of justices based on their judgments is akin to what the Rivers State government is doing. He's a supporter of the government. He's part of them. So the fact that they didn't take a decision that favors you, you come to the media to try to disparage them. You know no more than the justices. You don't know more than the Court of Appeal. These people have been tested hands over time, and they take their decision based on the facts that are before them and the law. So when you like to come to this media and begin to postulate things that are very unfounded, it's very unbecoming.
Mr.
And we will
Ikenga,
not allow
quickly.
him to impugn on the character of the justices.
All right.
We need to wrap up.
Yes, we do.
Shugbe Eli and Mr. Ikenga, we would like to have you both join us. We understand that Rivers State is the most important part of this whole conversation. You know, we hope that soon enough, you know, either through legal or, you know, political means, but somehow, some way, that there is some peace and understanding in the state and the state itself can thrive. Thank you very much to both of you for joining us this morning, and we would invite you again.
Thank you so much. That's our prayer. Thank you.
Thank you for joining.